January, it's, will be not, January 2015, it'll be 99 cents per month for this one.
So if I got that today, it'd be free?
Yes.
And then wouldn't charge me till January?
Yes. Yes. And there's several options to receive this box. You can, we can mail it to you, you can go to the local office and pick one up, or we can do a truck roll and do an in-home install, and that's the charge the counselor was talking about. It costs us money to send a person out and do an install, and certainly the technicians and our customer service people have the authority to waive fees if it's an elderly person and it's very obvious that it's difficult to install for that person. If we roll out with a truck and the box is, it's still in the box and it's obvious they've never attempted to even install it, and we feel there's no good reason, then we probably would not waive the fee in that case. But we'll do it on a case-by-case basis. We're not agreeable to do a blanket waiver for all fees.
Okay. Any other questions from the committee? Please.
Well, I was just thinking, referring to Councilor Clark's letter, he talks about concern about being in violation of our franchise agreement with Time Warner. So I'd like somebody to address that, and I'm not sure who.
Well,
can.
my thought was that we could have the gentleman from Time Warner talk to us, and then we go to the city attorney with our.
My answer is no.
I guess if we're ready to go there to the city attorney, how do you read it?
Well, let me preface my remarks by saying that I do not at all pretend to be an expert in the very esoteric and complicated field of cable television services and the provision of cable television services. In the run-up to this meeting, I have had to become much more familiar with those than I had in the past, and was quite surprised, probably shouldn't be, to learn how extensive a statutory and regulatory scheme exists on the federal level through the code and through the FCC regulations right down to the state. But in reality, this became a fairly narrow issue, which I was really happy about after I started getting involved in it. I mean, essentially, as I understood the issue as it came up from Councilor Clark and has been discussed here this evening, what happened was that as of this July date, and as far as I understand, notice of that change was made by Time Warner Cable to all the subscribers here in the city. I'll get into the regulatory requirement for that in a minute, but that notice was made to everybody in the city who subscribed to Time Warner and went out. And as of July 23rd, they made the migration from the analog system to the digital system. And that's what caused this problem. And then the question becomes, well, how does that apply under our franchise agreement? It's very important to understand that even though, as Councilor Clark has represented, this is an agreement between the city and Time Warner, this agreement is absolutely predicated and subservient to all of the other things that I mentioned on the federal side, the state side, the regulatory side. In particular, Section 7.10 makes that very clear, incorporation by reference. Basically, federal law, state law, the rules and regulations of the FCC shall control the interpretation and performance of the franchise to the extent that any provision of the franchise conflicts with or is inconsistent with such laws, rules, or regulations. So basically, the agreement that we have, although comprehensive in many ways, is still dependent upon going back out from the agreement up into the regulatory scheme to determine what is and what isn't permitted under the agreement. So when I looked at the question became, the migration happened from analog to digital. What was the implications for that, and where's the authority for that? In October of 2012, the FCC did issue a regulation that permitted what were then called, or maybe still are, because apparently Time Warner Cable has not finished the transition to a total digital system. Many cable systems were called hybrid systems. They were providing both an analog and a digital signal to their subscribers. And the hybrid system, as I understand it, was required by the FCC regulations prior to October of 2012. During the regulatory process, the FCC made a determination with the input from a lot of people, not just the cable companies, a lot of advocacy groups and consumer groups, that allowing the cable companies to transition to a total digital system would have consumer benefits. So the FCC decided to allow them to do that. But when they did allow them to do that, the regulation also required certain consumer protection measures. Those are sort of outlined in the notice that they provided. One of the consumer protection measures that was provided was this notice that they sent out prior to the transition to let everybody know. Now, when I was thinking about it and I read that notice, I'm not at all a technical person. I always rely on my kids, and now they're gone and I don't know what to do sometimes. But when I read the notice, it occurred to me that if I were a cable subscriber, it wouldn't mean anything to me. It really wouldn't mean anything to me until such time as I hit the button for the channel that I wanted that had migrated from analog to digital, and it wasn't there anymore. So that's why, as of July 23rd, this issue all of a sudden became a big one. So even though the FCC had required this notice, I suspect that a lot of people like myself probably would have read it and not really understood it until the channel went black. But what the rule also did was provide consumer protection measures with the understanding that not everybody has the digital capability for this migration. A lot of people still don't have the analog TVs, or in some instances they may have even have digital TVs that didn't have the necessary technical equipment in them. So what the FCC said was there's going to be a phase-in period. And under that phase-in period, you cable company must provide a converter box to allow these individuals to receive the digital signal at no cost for a period of time. And that period of time varies depending upon what classification you are under the regulation. For example, interestingly enough, if you're a Medicaid recipient, that period of time is 5 years. You have to provide evidence of that to the cable company. But in general, the period of time is a year, and in this case, Time Warner has extended that even more than that. I think it's a year and a half that they've extended it to. But the regulation did provide that they needed to give the boxes for free for this period of time and without charge. So they're in compliance with that. So the other question becomes, is there some other cost that's associated with the PEG access channel? And I think, as was pointed out, the PEG access channel under the franchise agreement, and again under federal law, is required to be provided as part of the basic service. And the basic service is a fee structure that changes from year to year. Unfortunately, people who have cable TV see their fee structure change. But the basic service is still being provided, and the PEG access channel is being provided even now under that basic service for that fee, whatever it may be. So there's no direct, as far as I can tell, there's no direct additional charge as a result of the PEG access channel being on the basic service. What the charge is that's associated with it is the necessity of having to have this converter box to access it. And that's why the consumer protection provisions went in. So my assessment, again, not being an expert in this field by any means, was that it doesn't appear to me to be a violation of the franchise agreement, especially and primarily because this change is being required of the cable companies by the FCC pursuant to rule, and the agreement incorporates that rule within its terms.
Everybody got that?
Questions from the committee, please?
Just a question, in the notice